Let's have a look at this case, which is an example of the application of the tort of interference with contractual relations. That tort is also commonly called the tort of inducing breach of contract. This decision of the Ontario Court of Appeal, called Drouillard and Cogeco Cable, involved a gentleman by the name of Mr. Drouillard, who was a cable and fiber optic installer. He had worked for Cogeco Cable for quite a while in the Windsor area up until 1999, when he resigned and took employment in the U.S. When he returned to Canada in 2001, he came back to the Windsor area and he accepted a job with a company called Mastech. Mastech was a cable industry contractor, and one of its main clients was Cogeco. When Cogeco found out that Mastech had hired Drouillard, Cogeco told Mastech that they would not allow Drouillard to work on any of its projects. Then Mastech told Mr. Drouillard, we can't have you working on the Cogeco projects. The only option is to get you to work on other projects farther away in London or Kitchener. Mr. Drouillard, could not, because of his family commitments, could not accept that alternative assignment, and that employment offer was revoked. Then several months later, Mastech hired Mr. Drouillard again and assigned him again to a project involving Cogeco. And again, Cogeco told Mastech that they wouldn't allow Mr. Drouillard to work on any of its equipment, and that caused Mastech to terminate Mr. Drouillard's employment. Because of this situation, Mr. Drouillard was unable to obtain any employment with any other Windsor cable industry contractor due to all the rumors that swirled arising from this incident with Cogeco. The legal issue that we'll focus on in this case has to do with whether or not Cogeco induced Mastech to breach its employment contract with Drouillard. In other words, did Cogeco commit the tort of interference with contractual relations? Please note that the court also considered another legal issue, which was whether or not Cogeco committed the tort of unlawful interference with economic relations. We will focus only on the part of the judgment that discusses the tort of inducing breach of contract, also known as interference with contractual relations. The court set out the requirements for the tort of inducing breach of contract, which is also called, again, the tort of interference with contractual relations. So to prove that tort, the court said that 4 elements had to be proven. First, Mr. Drouillard had a valid and enforceable contract with Mastech. Second, Cogeco was aware of the existence of that contract. Third requirement was Cogeco intended to and did procure the breach of the contract. And lastly, the fourth requirement, as a result of the breach of contract, Mr. Drouillard suffered damages. In applying those legal requirements to the facts of this case, the court, with respect to the first requirement, said that there's no dispute that Mr. Drouillard was hired in May of 2001 and did have a valid and enforceable employment contract with Mastech. So that first requirement of having an actual contract is met. The second requirement, Cogeco had acknowledged that it was aware of the contract between Mastech and Drouillard. So that satisfies the second requirement, that Cogeco actually knew of the contract between Mastech and Drouillard. So moving on to the third requirement. The third requirement is that Cogeco must have intended to cause the breach of contract between Mastech and Mr. Drouillard. In coming to the conclusion that Cogeco did intend to cause the breach of contract, the court looked at the factual findings from the trial. So there's a whole list of 6 different facts that were found at trial, which the appeal court used to support the conclusion that there was an intention to cause a breach of contract. The last element is that Mr. Drouillard must have suffered damages arising from the breach of contract, and the court here, the appeal court here, accepted the trial court's conclusion that Mr. Drouillard did suffer damages. He wasn't able to find a job in his field of expertise in the Windsor area, and he had to accept other lower paying employment.